म्यूट करिए ना, नहीं हुआ। Good evening, friends. As a lawyer, as a judicial officer, and all those who are interested to understand things in respect of injunctions, today's session, law and practice, couldn't come better from none other than Justice Roshan Dalvi, a former judge from Bombay High Court. And we have seen that how beautifully she explains the things, not only with reference of the legal journey, but also with quotes and her own style and inimitable style of explaining things, which makes things always better for any person to understand. We are so glad that we had asked Justice Roshan Dalvi ma'am to share her knowledge, and she has readily accepted. As usual, her acceptance on all different topics is what fascinates us, that she's always willing to share the knowledge. Over to you, ma'am.
Good evening, friends. The law of injunction is one of the most important and the most used law in civil law practice. It has a substantive and a procedural aspect. Even the procedural aspect is partly substantive. We must understand what is the usual law of injunctions first, and then the specialized injunctions, which is judge-made law. So, friends, what is an injunction? It is a judicial process in personam, means against a particular defendant, requiring the defendant to do or refrain from doing a particular thing. This is what Black's Law Dictionary states. Such injunction is therefore to do, which would make it mandatory, and to refrain from doing, which would be prohibited. We'll go to various types of injunctions soon. Now, this law of injunction, where do you find it? It is in the Specific Relief Act, Part 3, Chapter 7. It is a preventive relief, and Chapter 8 are perpetual injunctions. So, preventive relief is prohibitory, and perpetual injunctions are forever. So either it is prohibitory or mandatory, either it is temporary or permanent. These are the various facets that you know of the law of injunctions in the Specific Relief Act. In the Civil Procedure Code, under Order 39, Rules 1, 2, 3, and 4, we have the law of injunctions, when it could be granted. Whenever there is waste of property, whenever the defendant is going to cause damage or loss to the plaintiff or to the plaintiff's property, then an injunction is granted preventing the defendant from doing so. That is the basic law. Okay. Under Rule 2, we have a continuous injunction. That means an injunction which once granted continues until it would be revoked. Rule 3 is a procedural aspect. It requires every plaintiff to give the defendant notice of the application to move an injunction. Now, this is an interim or an ad interim relief. It is pending a civil suit. In all matters, essentially, notice has to be given. There would be some certain matters where, if notice is given, the property may be wasted or damaged or done away with, in which case, upon the court being satisfied, the court would issue a temporary injunction for a particular length of period, for about, say, a week or so, without notice to the defendant. Now, when such an injunction is granted, then Rule 4 says that the defendant can apply for setting the injunction order aside or for modification of the injunction order. Once the defendant applies for that, then it is as if now he has got notice, the defendant shows his case, and on merits, it would once and for all be decided whether the injunction has to be granted or not to be. Now, the types of injunctions, as I told you, under the Specific Relief Act, preventive or prohibitory are under section 36 to tell the defendant to refrain from doing a particular act. Generally, these are granted in terms of property, in cases of properties. So you don't have to deal with that property, dispose of the property, or alienate the property. The property remains and the suit can go on and be decided, so that then a perpetual injunction would fall. So under sections 37 and 38, there are these temporary and perpetual or permanent injunctions. The other kind of injunction is mandatory injunction. Mandatory is to ask the defendant to do a particular thing. Create a wall between the plaintiff's property and your property is a mandatory injunction. It is more drastic, and therefore a very strong and clear case is required. Then, under the Specific Relief Act, Section 40, we have damages in lieu of injunctions. Because in all matters, injunctions may not be granted. If the property is capable of some kind of damages and monetary relief or compensation, then injunction may not be granted. The defendant may be allowed to do a particular thing, and upon failure or upon any damage being caused, damages can be granted. For example, there are projects of construction, and the construction is in a layout of a vast property, and only one plaintiff comes with one unit in his with him. It may be a flat, it may be a shop, or whatever, and asks for an injunction against the construction. Such injunction orders cannot be granted except for his property, or it would not be granted even for his property if ultimately it would be compensable in damages. Now, Section 41 lays down various aspects when no injunction can ever be granted. So, prosecuting in court, nobody can say, don't file a suit against me, or don't file a criminal application against me because I think it is frivolous. Such an injunction can never be granted. To prevent breach of a contract which is not specifically enforceable also, an injunction cannot be granted. The contract, if any, must be specifically enforceable. That specific performance of the contract would be granted at the final stage. And at the interim stage, an interim injunction can be granted to protect the property so that the final order can be passed on merits, not otherwise. Now, when nuisance is alleged, some kind of nuisance, noise nuisance is also nuisance. We live by that nuisance all along, everywhere. Then dust nuisance nowadays is a real nuisance. But unless there is a clear nuisance made by the defendant which damages the plaintiff or his property, plaintiff's health, for example, or his property, the order of injunction will not be granted. Then when the plaintiff himself acquiesces in a particular act, the plaintiff says, okay, I will vacate my premises, for example. And the plaintiff has not vacated the premises, but wants the defendant not to construct further or not to construct on the neighbor's land or something like that. Such an injunction also won't be granted because the plaintiff himself says you can do it and I will vacate. And until the plaintiff vacates, the defendant cannot do it. So these are the usual such cases. Then when there is other efficacious remedy, like for example, mainly in damages. But if there is a remedy that if you don't get one piece or parcel of a land, you can get another parcel or any such thing, then an injunction for the whole property will not. Under the latest amendment of 2018-19, the infrastructure projects are protected everywhere. So when there is an infrastructure project, no one can be granted an injunction against it. If there is any loss, harm, or damage, it is always compensable then in money by that infrastructure person. The plaintiff's conduct will always have to be seen, because when the plaintiff comes to court with unclean hands, when the plaintiff comes to court without a clear prima facie case, etc., no injunction can be granted. If the plaintiff doesn't show that the injury is irreparable, but it is repairable. Some injury may be caused. Like, for example, there is a construction in the adjoining land, and because of the construction, there is a crack in the wall. Now, that can be sort of undone. It is not irretrievable. Then injunction will not be granted because plaintiff's conduct also could be seen. When the plaintiff has no personal interest in the matter, he doesn't have the direct locus, and he comes on behalf of somebody else, injunctions would not be granted. So, aside from these cases, in a case where a plaintiff makes out a prima facie case, shows irreparable loss, and there is not balance of inconvenience for the defendant, injunctions would be granted. We'll go to these three aspects a little later. Then there are some documents. Documents of title between parties. For example, a large land has to be developed and a part of the land is being developed. There is a right of way created. And then there is a negative covenant that I will not do a particular thing or I will do a particular thing. To enforce that negative covenant also, injunctions are not generally granted. Now, what are the factors for the grant of injunctions is very important. The prima facie case, as we call it, is the very first principle. It is the plaintiff's burden. The onus lies on the plaintiff to show that he has a prima facie case. That prima facie case generally is made from documentary evidence. Because nowadays we have injunctions in matters relating to property. It may be in family law property, it may be against builders, it may be in various projects, whatever. So the title of the plaintiff and the document under which the plaintiff has applies for that relief, a particular clause, clause 3, that the defendant has agreed not to do a particular thing, but he is doing that particular thing. He was to construct up to the 7th floor, but now he is putting up the 8th floor. Stop him, because that will impinge upon my FSI. So that kind of a case will have to be shown by documentary evidence. It should be an arguable case showing a reasonable dispute. If not, like for example, in the case of nuisance or some such thing, or case of sort of the minimus non curate lay, the defendant is putting up some flower pot in my land and all. In those cases, injunctions are not granted because there is no reasonable dispute which is shown, the burden of which lies on the plaintiff. There must be a substantial question of law. The law is that the plaintiff has applied for rescission of the contract, plaintiff has applied for specific performance of the contract under a particular document is cancelled and the plaintiff is applying for relief for restoration, whatever it be. Those are the questions which would be decided in the suit. And then if a prima facie case is seen by documentary evidence, injunction will be granted to protect that property. So the bona fides of the plaintiff are very important. And when the plaintiff comes, and quite often they do nowadays, come without bona fides, then injunctions can, would, and must be refused. Then the second principle is the principle of irreparable injury, which I told you about earlier. If the injunction is not granted, the plaintiff would not be in a position again to have the same thing that he had before. That would make it irreparable. Usually in a case of dispossession. If the plaintiff claims that the plaintiff is in possession of the property and shows documents relating to possession, then the plaintiff is entitled to an injunction, whether or not it is for protection of possession or for recovery of possession. Now, these are under sections 5 and 6 of the Specific Relief Act. So the plaintiff, if the plaintiff is in possession, if the plaintiff is not in possession, would ask for recovery of possession. The plaintiff has given the flat on license basis and the license has expired and the plaintiff wants the flat again, or it is a tenancy and there are grounds of tenancy. where the plaintiff is entitled to the premises back again for bona fide requirement of a defendant having constructed unlawfully or whatever, then the plaintiff would be granted the injunction. But if the plaintiff cannot show his title, but the plaintiff can only show possession, the plaintiff is in possession, nobody can take law in his own hands. And therefore, a party in possession must be protected until the owner applies due process of law and recovers the possession. In those cases only, injunction can be granted against the owner. Otherwise, the real fundamental principle is there can be no injunction against the true owner of the property by a trespasser, by a neighbor, by an outsider, whoever. The last is the balance of convenience. Now, that is to be seen on the other side. This is what the plaintiff must show. But the plaintiff, having shown a prima facie case and irreparable injury, in some cases, the balance of convenience would be in favor of the defendant. The defendant would say that this is correct, but unfortunately, such and such a thing would happen to me. If the defendant's case is bona fide, for balance of convenience, the injunction won't be granted, but what we call a workable order is made out. Now, let us see, for example, there are two brothers. They have succeeded to the property of their father. One brother is in possession. The other brother wants to come in possession. He files a suit, and the first brother wants to dispose of the property because he is in possession and on his title. The defendant says that the balance of convenience is in my favor. He cannot dispose of the property. So he files the suit. In other words, it's the plaintiff. So this balance of convenience has to be seen for fair play between both the parties. And this is the true discretionary relief. And this discretionary relief has come from precedent to precedent because we follow the common law. You see, it is unlike in a civil law countries where there is nothing like a discretionary relief. But here, when the injury that may be caused would be disproportionate to the damage which will be caused to the defendant. The plaintiff may say that you give me possession, but the defendant will say that I have been living here all my life and I cannot be dishoused. So that kind of an injunction would not be granted. We would say that you keep the property, you be in possession of the property, but don't alienate it further, etc., etc. And only that kind of an injunction may be granted after seeing the convenience of the defendant. Now, this is power balancing on both sides for fair play. Now, all these are the usual injunctions, and in various suits they can be granted, which I'll come to a little later. But before that, the different kinds of injunctions that we must see. There are specialized injunctions. One specialized type of injunction is the Mareva injunctions. It is generally granted for financial frauds for now the crypto assets and cryptocurrencies. These are the freezing orders. Now, this Mareva was a ship, and there were charter parties and sub-charters. There were 3 installments to be paid. 2 were paid and the third was refused. So this money was in a London bank. And the Consul General of India applied for freezing order because they said that if they come to know that we have filed this suit, they will immediately transfer this money out of the bank account. So freeze the bank account. And these Mareva injunctions would be granted without notice to the defendant also, but for a short period of time until the defendant would come and give his side of the story. So these are injunctions against sale or alienation of properties also. If a property is just going to be sold, the plaintiff applies and without notice to the defendant also may get a Mareva injunction. This is, I would say, like the attachment before judgment proceedings. The plaintiff would have to show a very strong case, not only a prima facie case, of a case that he will win at the time of the final hearing and a case of disproportionate injury to the plaintiff something that is irreparable. Then the other specialized injunctions are called John Doe injunctions. These are against parties who are wrongdoers who are not identified. We increasingly have these kind of matters because of our cyber work. So there are unidentified wrongdoers like the internet users, these are the hikers, the cable operators, etc. Now in this there is one matter where there were John Doe and John Doe 1, 2 and 3. Injunctions were granted against John Doe 1 and 2 but not against 3 because a very strong case was not made out against him. And in this case, especially in case of defamation, when you say that this is going to defame me, stop him from doing it, stop him from publishing. There are two rights which the court will have to balance. One is the right of the plaintiff, naturally not to be defamed, but also the free speech of the defendant. So this John Doe case came about in New Jersey, and they considered the First Amendment to the US Constitution, which is the amendment of free speech. We have this under Article 19(2) of our Constitution. And this is what the court will balance. You cannot say, don't do this because I don't want it, because that is misuse. Only if it is going to defame a particular person, and to that extent only, such injunctions would be granted against some wrongdoer who is not known. Those are called the John Doe instructions. Now, what happens is, usually these are not cases of defamation only. These are cases of online piracy. The questions where trademarks, patents, copyrights would be infringed under those acts. So these are IP infringements under the Copyright Act, Trademarks Act, Patents Act, etc. Then in those cases, what generally happens is that the court grants an order for discovery. Discovery against the wrongdoers. The plaintiff's damage is weighed. And when a discovery is to be made, the court may also tell the police to investigate in certain cases to find out who are these wrongdoers and then grant another injunction against the person who has been found. Then there are dynamic injunctions. Dynamic injunctions also are for online piracy and AI generated infringements. These would be now more and more used in civil courts. This involves continuous wrongdoing because online piracy can go on and the computers will be hacked for so many clients, etc. So this involves continuous wrongdoing and a continuous injunction order is required. Then there are what are called Anton Pillar injunctions. Now these are important. One Mr. Pillar, his first name was Anton. He was the plaintiff in a case. And these are for corporate frauds, IP theft, cyber crimes, etc. Now, in that case, what happened was that the plaintiff had certain machines and his diagrams and tables relating to the machines which were to be operated. The plaintiff told the defendant to put it in a software program. So he had to give him the particulars of the machines, diagrams, etc. The defendant was to make the software. But the plaintiff had a copyright in his own machines and his own diagrams because that is artistic work. That is the work, even if it doesn't have artistic appeal, it is artistic work under the Copyright Act. So the plaintiff had to safeguard his copyright. The plaintiff learned that the defendant, whilst making the software, and for which he will have a copyright, he wants to use my diagrams for my competitors. So this had to be stopped. So this was a kind of IP theft. Okay. Similarly, for corporate frauds, when there are frauds by companies and when the company's trade secrets are taken away, either by an employee or by a competitor or whatever, then anti-pillar injunctions are granted. Nowadays, for cyber crimes also, anti-pillar injunctions would be granted because by virtue of that cybercrime, a computer being hacked, somebody's IP would be in danger. So what the courts do actually is first give an order for inspection and seizure of the property. Now in that case, the trial court gave an order that the plaintiff will go to the defendant's place. This was in England and Germany. The plaintiff had to go to the defendant's place and show the defendant, and the defendant was to show the plaintiff all the diagrams, etc. Now the question arose that the defendant may not show, but when the court grants that, it would be to his peril. It would be a contempt of court, and he could be committed. Therefore, generally the defendant would show. And the plaintiff, upon seeing that these are his machines and the diagrams of his machines, may be able to seize those papers at least, so that he would prevent a further infringement of his own copyright under the copyright of the defendant. So it's very interesting. These are for inspection of the properties to prevent misuse of the properties. This can be granted for a short period. It can be granted with certain directions. But once granted, generally the defendant's advocates, unless of course the advocate gives wrong advice, would advise the defendant that you show all of these things that you have, because it is a case that the defendants have been given those diagrams. So you show the diagrams are with you, and the plaintiff can then seize the diagrams and stop the misuse. So these are specialized injunctions. But very often, and 90% of our cases, deal with the usual cases, which we will go to. These are the various types of cases. Partition suits. Now there are co-owners or co-parsoners. It may be an HUF property, and there are co-parsoners. Every co-parsoner is entitled to partition the property. So when there are co-parsoners and it is admitted that there is an HUF and there are co-parsoners, or if there are co-owners and it is admitted that these are the co-owners and this is the suit property, once that is done, under the CPC, a preliminary decree has to be passed. You don't have to take any further evidence on this, because these are admitted facts in most of the cases. There are four brothers. They are owning the property as a joint property or as an HUF property. And one of the brothers wants to partition the property. He has every right to partition, just as, say, a partner has a right to dissolve the firm. Okay? Once that is established, a preliminary decree has to be passed. Now, when you're going to pass a preliminary decree, when the court will pass that, it is something like a decree on admission under Order 12 Rule 6. But under the specific provision of Order 20 Rule 18. So the preliminary decree would therefore require that until the final decree is passed, the property is protected for that co-parsoner. So either the entire property or at least the share of that co-parsoner cannot be alienated. There can be injunctions then. And anyone can apply for those injunctions. And if the lawyer is appearing for the defendants, you may say that the entire property cannot be injuncted against sale and alienation. We want to sell our share, so let us do that, and the plaintiff's share will be protected, and thereafter the plaintiff may claim from the same purchaser or another purchaser. Then administration suits are much like partition suits, except that the title of the property was with someone else earlier. So it may be the father, grandfather, husband, wife, whatever, and that person has died. It is either intestate succession or testamentary succession, depending upon which and where you come from. In Bombay, Madras, and Calcutta, you would require a probate of the will of the deceased. And if it is intestate succession, you require letters of administration of the will of the deceased. If there is no executor, then letters of administration with the will annexed. And in such an administration suit, you have to prove your title. So probate is granted by the testamentary court. Letters of administration will be granted by the testamentary court. But the declaration and injunction of title and the prevention of misuse of the property will be granted by the civil court. In these matters, generally, injunctions against alienation and transfers are always granted because the property is required to be protected for all the heirs or for at least the heir who has come to court. Then there are suits upon loans. Now, there is a lot of mischief in these kind of matters that is seen by the courts. A person takes a loan for a flat. The loan is payable in equal installments during a 5-year period. The party who takes the loan pays the EMIs, as we call it, the equated monthly installments, 2 times, and then makes a default. And then says, see, this is a loan application, this is my loan agreement, and this shows that I am the owner, therefore grant me an injunction against the defendant, that is the bank or the financial institution which has granted loans. Sometimes it may be a private party also, restraining him from selling my property. Now, this is when the plaintiff comes to court with unclean hands. The plaintiff doesn't show a bona fide case. The prima facie case has to be seen actually. And the defendant must show that there is no prima facie case. He is supposed to pay 12 into 5, 60 installments. He has paid only 2 installments and he cannot get the property saved. Therefore, we would be entitled to sell the property. And courts should not and generally do not grant injunctions in these loan matters. Then suits against municipality. This is also, of course, misused, very much misused, granted by the court, which is also quite often wrong. And what happens is that is how so many cities have become middle-class slums. Now, encroachers encroach upon roads. They encroach upon private property. They encroach upon government land. They apply to declare it a slum under the Slums Act. They want to sue the municipality from demolishing their unauthorized construction. The municipality may be giving a notice. The municipality may have given a notice that your construction is going on, stop it. He completes the construction quickly and then says that I have not got notice, my construction is complete, I am the owner of that property. Now, under the jurisprudential aspect, if you see, as a law student, if you are an owner, you can do anything that you want with your property. You can set it on fire. Nobody can do anything about it and nobody can sue the true owner. But that doesn't mean that an illegal act of the owner can also really require an injunction. These are people who come to court with unclean hands. Now, when you have to construct a property, you have to do it under certain plans of the municipal corporation or the municipal council, depending upon whether you are in a city, in a metropolis, or in a town. And only under the approved plans, as per the approved plans, which takes into account the compulsory open space, the road, etc., the parking spaces, all of those things, then you put up the construction. If the construction is put up exactly as per the plan, an injunction against the municipality would be granted. But most of the cases are not like that. Most of the cases are where the construction is against the plan or in extension of the plan or without the plan whatsoever. Now, if it is without the plan, then there are certain notifications issued by the municipality allowing or what they call tolerating certain unauthorized or irregular constructions. If they are tolerable, then injunction can be granted. If they are not tolerable for irregular structures, no injunction can be granted. Now, there was a very interesting case of a person who put up an unauthorized bakra, as we say, for pan bidi and those small articles on the wall of a building of a cooperative society within the compulsory open space of the society. The plan, which is annexed as Exhibit A to the plaint, shows that there is a square. Inside the square is another square, which is the building. On the wall of the building is my pan bidi stall. which is in the compulsory open space. Now, no one can construct anything in the compulsory open space. The compulsory open space is about 15 feet on all sides. And as you go higher and higher in the building, it would be 1 foot more under the rules. Sometimes the rules are amended. In Bombay, also, DC rules have been amended because there is so much of construction and there is not so much of land. But as per the latest DC rules, it could be constructed. You cannot put up a bakra in a compulsory open space. Now, the question that arose was, has the plaintiff come to court with clean hands? No. The plaintiff himself says that I have put up this bakra on the wall of the building in this compulsory open space, and the society and the has complained to the municipality, and the municipality wants to come and demolish my bakra and let the municipality not do that. How can any injunction be granted? The injunction cannot be granted. The plaintiff's case is not bona fide. The plaintiff's case is illegal. And actually, under Order 15, Rule 3 of the CPC, which is now deleted, unfortunately, it is a very salutary provision. But when we got the case management directions under Section 15A, somehow Order 15A, somehow Order 15 came to be deleted. And the Order 15 says that if on the plaintiff's own showing you cannot grant it, if something is illegal, then there is no need to go on with the suit. The suit must be immediately dismissed. A very salutary provision. Now that provision is gone. Injunctions are applied for. They are generally applied for unauthorized constructions. So when there is a tolerable date, like say 1989, up to 1989, if your structure has been there, the municipality will not demolish it. The plaintiff comes to court showing the assessment bills of 1999 onwards, let us say. Now, there are no assessment bills earlier. That means you cannot show prima facie also that there was a property which was assessed by the municipality. How can an injunction be granted? But the plaintiff says, this is my property. Today I have got this structure. Therefore, today you protect the structure. And the courts protect it. The courts grant injunction. Completely wrong. It is against the prima facie case principle. And to my mind, it should never be granted because hundreds of such injunctions are granted. There are people who are today trying to construct. They corrupt some municipal and government officers. They get some kind of a commercial license, shop and establishment license. They get some assessment bill. They show that this property is there today, so protect it. And that is how we have got all the slums all around. Now, interestingly, there were cases where in Mumbai, and I'm talking mainly from the Mumbai experience, MHADA, that is the Maharashtra Housing and Area Development Authority. MHADA constructs various buildings of various sizes and to suit various purposes. So this is LIG, MIG, and HIG. Low income group, middle income group, and high income. Okay. Now, these flats are constructed. And once the construction is nearing completion, the electricity connection is made, the water connection is made to get the occupation certificate from the municipality. Now, as soon as this electrical connection is made, the electricity company starts issuing rentals for the various flats because electricity connection is made in all the flats of all those buildings. Now, whom do you serve it upon? There is no occupation certificate granted. Nobody has come to stay in the flat. The flat is locked. It is with the executive engineer of MHADA. The electricity bills are put in the L drop of the flat. Some miscreants pick up these electricity bills. They say that we have got this flat. I have applied for this flat. No document is shown. They only show the electricity bill. I am in possession. It is a residential flat. I am living here. This is my ration card, etc. Some few documents which are obviously got up. Okay. And you apply for an injunction only on the ground of possession. but the document with MADA is not shown, and they say it has not yet been made because MADA will be issuing the letter of intent later. Some courts have granted these injunctions. Now, that is also completely wrong. It goes against MADA and against the party who has been allotted that flat by MADA. Because how will that party get into possession? This is a wrongful occupation and a party coming to court with completely unclean hands, a dishonest case. Now, such a case had come up before me. And when I saw the electricity bill, I said, okay, how big is the flat? The flat was some 1 bedroom, 2 bedrooms, whatever. How long have you been staying there? So and so. What all electrical equipments do you have? Etc., etc., etc. So and so are there. The electricity bill, if you read from the back, are only for rental. And not a single unit is consumed. Now, this is what the courts would see. So when a plaintiff comes, and some lawyers would go to the court thinking they are very smart, but they are not. The judge would be smarter. The judge would not only see the electricity bill and those 30 or 45 rupees that is charged, the judge would see what it is for on the rear of the bill. And it is only for rental. No prima facie case is made out, and against the municipality or against MADA or whatever government authorities, no such injunction can be granted, would be granted. Then suits in rent court. Now in rent court, the owner may apply, that is the landlord. He may apply against one or many of his tenants. In a building, there may be more tenants. He may have a case against, say, 8 of the 28 tenants that he has. It may be applied by the tenant against the landlord, restraining the landlord from dispossessing the tenant. And in that case also, prima facie case becomes very important. One is the landlord's case, where the landlord would show bona fide requirement, where the landlord would show unauthorized construction, various other things which are given in the Rent Control Act now of 1999. And the court will decide whether there is a prima facie case or not. The tenant or the person who claims to be the tenant may or may not be the tenant. He may be a licensee. He may be the licensee of a tenant because a tenant has subtenanted the premises, which is itself illegal. Unless, of course, it falls within that period. Like here it is July 1973. Then all the licenses became tenants. But unless that is done for a licensee who has come, say, last year or a year before, and saying that no, because I pay license fee, I'm a tenant, no injunction can be granted to protect his possession because he would be coming with unclean hands. And of course, the court might say that the landlord cannot take possession himself because you can't take law in your own hands. So the landlord will have to follow the procedure under law. What is that law? The law is for recovery of possession. That is under Section 5 of the Specific Relief Act. So until that is done for that short period, the injunction may be granted also, even in case of a licensee or a gratuitous licensee also, because once you see the possession has to be taken by lawful means. Aside from that, now the question is, the landlord sues for recovery of possession. As soon as the landlord sues that, he follows due legal process. When he follows due legal process, that injunction must come to an end. In a fine case where the lawyer rightly advises, the lawyer would apply for vacating that injunctive relief. I have applied for recovery of possession. But when the landlord applies for recovery of possession, then the court would also see the balance of convenience of the defendant. Seeing that, the court would say, yes, he is not in lawful possession. He has exceeded his possession, but he is still in possession. So until I hear the suit, because the suit will have to go on and the document will have to be seen, except if the document is an admitted document, which doesn't have to be proved in evidence, and a judgment can be passed on admitted document immediately. Unless that is done, until that time, the defendant is allowed to stay, but with various directions that he will not misuse, that he will not construct, that he will not deal with, dispose of, transfer, etc. So these are the injunctions generally in the rent. Then there are suits for accounts. This is in partnership disputes, in disputes between the principal and agent, in disputes between contracting parties, where both parties are neither agents nor partners. And the one party, that is the plaintiff, says that I am entitled to so much before I say dissolve the firm, or when I have applied for accounts and before accounts are taken, some kind of injunction to protect the bank accounts, to protect other assets of the company or the partnership firm can and would be granted. These are temporary injunctions again. And when the firm is dissolved, then of course the order for dissolution of the firm and making up accounts would be done, until which time also all partners cannot dispose of any of the amounts which are lying to the credit of the firm or in the capital of the firm. Then there are suits for specific performance. Now there are one too many. These suits are generally for flat and unit purchasers, shop purchasers against the builders, but there are also many for builders against the flat purchasers in layout plans, etc. For so many buildings which are being constructed. Unless the flats are being sold or the shops are being sold after they are fully constructed, then the transaction becomes very clear, and generally there is no case for specific performance or injunction. But when you start taking, the builder starts taking EMIs, for example, you have to pay the installments. The party pays the installments, but the builder does not construct as much as he should have constructed as per the agreement, because there are slabs given, and slabs for payment and slabs for construction. And the slab for construction has come up to 3, but the payments are 7 that are being made. The party says, I will not make the 8th installment now. Why should I pay it? You stop the construction. You go away. You put in another builder. All sorts of claims. Now these claims are to be made under RERA, because there are builders who are supposed to register this under RERA, and the parties will have to go to the RERA court, where first mediation takes place. There's a specified mediation, statutory mediation under RERA. Like, for example, there is under the Commercial Courts Act, there is under the Consumer Protection Act. These are statutory mediations. So when they are mediating, a novatio can be made. That novation of the contract would be that, okay, I'm granting you more time, for example. Now you construct. Until you construct this, I will not make any further payment. So the builder is not injuncted from constructing, and the party would get, the unit purchaser would get his unit. So this is also discretionary relief in a specific performance suit. Conversely, the builder may apply for specific performance. And specific performance are applied for in many cases where properties are going into redevelopment, for example. There are so many persons in a cooperative society or in a condominium or in an apartment building or even in a tenanted building. And the builder makes agreements with various parties. And there are some parties who abide by that agreement and they vacate. There are some parties who do not vacate. The builder applies for specific performance. He applies for appointment of court receiver of that property. Now, in those cases, injunctions would have to be granted because those parties have been given what the builder has promised to give, or the builder wants to deposit in the court if the party doesn't want to accept it. But the entire construction cannot be stopped. So a limited injunction is granted, the construction is allowed. Suits between neighbors, not many, but there are some suits between neighbors, especially for injunctions, for trespass in the open space or in the passages or behind the building or some such things. Then seeing the prima facie case, injunction may or may not be granted. I had a very interesting case of flower pots. And one neighbor said that his flower pots are causing a nuisance because rats are coming and eating up some seeds and whatever. So tell him to remove the flower. And the other man says there is nothing of the kind. I am maintaining it. It is causing this. So we had to make a workable order. I mean, thinking of a very interesting sort of an anecdote where a professor gives a case study to the students and says, you are the plaintiff and you are the defendant. And the case study shows that one defendant says that my tulips are being crushed by the apples which come out of my neighbor's property, which fall from my neighbor's properties, trees, which are right on near my property. So the students have made a big sort of a presentation on injunction and insurance and some, specific performance relief, etc., etc. The other party then makes up other things of irreparable harm and damage, inconvenience, etc., etc. Professor looks at all of those presentations. He is not impressed by any of them. This is where the lawyer's skill comes into play, he says. You are going to be lawyers. And what kind of lawyers will you be? Just lawyers that your client comes and tells you something, so you file a big long plaint and apply for any relief. And the defendant also will just give a written statement showing anything. The professor says, tulips grow in spring, apples fall in autumn. And everything was dismissed. So this is the true test of what would be a prima facie case for injunction. There are other suits. Suits for recovery of possession. I actually already dealt with this. And suits against dispossession. These two can be taken together, sections 5 and section 6 of the Specific Relief Act. And I told you when injunction can be granted. Now suppose there is a license and it is a gratuitous license. A man allows his nephew to stay in his flat. The nephew brings in his friends and he makes a nuisance and he damages the flat and he doesn't take care. He's a bachelor. The man says, enough is enough. I want my flat back. So he applies for recovery of possession. The nephew says, I am a tenant or I am in adverse possession and therefore he cannot get any injunction. Now, if he is a tenant, he has to go to the rent court and not the civil court. If it is only a gratuitous license, as the plaintiff claims, he comes to the civil court. So the court's jurisdiction would have to be seen. We have to see whether under Order 7, Rule 11, the suit would have to be, the plaint would have to be rejected or sent to proper court for filing. And if it is for adverse possession, then it is a title by prescription. There can be no injunction against the true owner. He has now become the owner. But what does the court have to say? The court will have to see the case of the plaintiff and not the defense of the defendant. If the case of the plaintiff shows that there was a gratuitous license and the defendant has not been able to show that he was in adverse possession for 12 months, which is possession hostile to the true owner, and if the possession is permissive, injunction would have to be granted. At least the injunction against dispossession would have to be granted. He would be continuing in possession until the suit reaches hearing. Then suits by parents against children. Now this is a very interesting history. It started in the 1980s. It came about in one case called Conrad Dyers versus Joseph Dyers. The father, who was the owner of the property, he lived there with his wife and his son. His son was a nuisance. The father did not want the son in his house. So the father applied for an injunction against the entry of his son. The son, as expected, as all lawyers of the defendants do, took up defenses of being a tenant, of being a licensee, of being in adverse possession. All of these defenses could not be taken. He should have taken one of them, but he took all. And that only showed what kind of a defense he would have. The court held that this is the property of the true owner, the father. The child is neither a licensee, nor a tenant, nor in adverse possession. He is only living there as a family member, nothing more and nothing less. Very interesting judgment, very short judgment. This judgment was followed in another judgment similarly. Once these two judgments came, and that really shows how good laws, good judgment, good procedures are misused and abused in our legal system, so many suits came to be filed by some children against their parents or parents against their children. Now, when a parent sues the child, it was seen so often that this parent is suing at the behest of another child. There are siblings. One sibling is in possession. Another sibling wants to get into possession. He instigates his father or his mother, who is very old, almost incapacitated, to sue the other one and obtain an injunction against the entry of the other person who has an equal right otherwise if there is going to be intestate succession, unless of course it's an immovable it's a ownership property and a will is made. Similarly, children apply also against their parent, and now it will be covered by the Senior Citizens Act, where this kind of injunctions are refused and the senior citizen's possession is protected by that tribunal. So all of these things are there. I had a very interesting case of a mother-in-law suing her son and her daughter-in-law. And the son, such a good son that he was, he did not file a written statement. So he said, "Oh, my mother is right. I am a nuisance. I am a useful, good for nothing son. Therefore, please throw me out." In short, the mother-in-law said that this is my property, this is my name on the rent receipts, on the society bills, etc. And therefore, both must go. The daughter-in-law filed a separate written statement in my court. And the daughter-in-law showed me that her marriage was on the rocks because she had given birth to 4 girls. And she said, "My mother-in-law and my husband wanted a boy child, which is the usual Malay in our Indian houses." Now she said, "After the first child, I was not treated very well. After the second child, I was really mistreated. After the third child, there was a lot of domestic violence. And after the fourth child, they actually threw me out of the house. So I went to the family court and I got an injunction against my dispossession, but I am going to be dispossessed. I'm going to be dispossessed." She was not dispossessed, and she sued in the family court, and then she applied as a defendant for not granting her mother-in-law the injunction. Now, what she also showed me was that yes, the property does belong to the mother, but how did it come? This mother had a small unauthorized construction that was demolished and a new building came up. In that, she got one tenement. Now, naturally, it would go in her name. So it was in her name. But she was retired, etc. She didn't have any means. And therefore, the son and the daughter in law were paying electricity bills, gas bills, etc. The daughter in law was also working. And they were paying the society charges, though the bills were in the name of the mother in law. So I held that there is a trust. Yeah, it is a kind of a trust that when there is a property where somebody else has put his income or even his work, for example, if it is constructed into it, then he has a beneficial right. So it's a beneficial trust. And Lord Diplock's case was seen, and he said that that is a real flower in the orchard of English law. This is what common law can do. So not only the injunction was refused, but that case was dismissed after taking evidence which I found like this. Okay. Then suits for recovery of monies lent. Many suits, now they go to the magistrate's court because there are dishonored checks. There may be a promissory note, there may be a bill of exchange, there may be a dishonored check. These are all negotiable instruments. And suits have to be filed for monies lent. For example, there may be a loan agreement, and the financial institution would have to sue to recover in a debt recovery tribunal, whatever it is. So, for those monies, like the suit for loans, we would say that if various installments are paid, very little is remaining, usually an injunction can be granted. But if that is not done, then no injunction can or should be granted. In suits against construction. Now, this is where the defendant's balance of convenience also would come into play. Of course, the plaintiff's prima facie case must be first seen. Whether there will be irreparable or reparable injury also would have to be seen. If there is going to be a construction even later, it would be reparable. Okay? But if by stopping the construction, others also would get affected. Like, for example, like a person is buying a flat in a building and you stop the construction of the building, so many other flat owners will not be able to get their flats. Now, this is where the defendant, who is the builder, who is the developer, his uh, convenience would also have to be seen. An injunction may or may not be granted at all, or may not be granted at all, or it may be granted only for a certain property to a certain extent. Like, for example, the courts generally say you continue construction, but one flat will not be sold, so that that flat will be given to the plaintiff. Okay. Then suits of commercial contracts. Now, there are many such suits, and now there are many arbitrations in commercial contracts where injunctive reliefs may have to be granted in certain cases. This would be for protection of some kind of money and financial transactions from certain bank accounts, etc., for showing that a particular party has got some kind of a standing so that he gives some security to the other party in a commercial transaction, or simpliciter in a commercial transaction where there are contracts for various constructions, buy over contracts, etc., where there are tenders being floated. Then, seeing the terms of the contract, certain injunctions would or would not be granted. It is granted by the courts under Section 9 of the Arbitration Act, if there is an arbitration, under Section 17 by the arbitrators themselves, if the arbitration has started. And in suits of commercial contracts, there is, as I told you, a compulsory mediation. Now, this compulsory mediation would take place with a couple of exceptions. One is, of course, where the defendant does not consent, because you can't pressure a party to settle, even though it may be for his benefit, actually, because it's a commercial transaction, it will get over quickly and he can go back to business. It is always in his interest also. But if there is an injunction application, then there will be no mediation. So what happens is that in commercial contracts, parties needlessly apply for injunctive relief. And then they say that, oh, there is an injunctive relief, therefore there will be no mediation. But what I would argue is that an injunctive relief which is pending is there, and that has to be decided, because some modicum of injunction would have to be granted pending the mediation. Otherwise, some property may be depleted, and the mediation may continue just to defeat and delay the claim of the claimant or the plaintiff in the suit. So that is true. But once an injunction is granted or refused, then there is no injunction application. So when that is done, at that time itself, the courts do and must pass directions for mediation. And if this gets really well settled, as it is, say, in Bangalore or in Delhi, then it is really very good, because these are business parties. They have brute common sense. They don't want to come to court and waste their time. They want to enter into other contracts. And therefore, they are always agreeable to have a novation of the contract by way of some kind of a mediation and then get going, or give up a part of the contract so that they can get one part of the contract and take up another contract. If that does not happen, it is generally because the advocates don't make it happen. This is the truth, and so I say it. Then applications for protection of possession of a matrimonial home by a wife. Very interesting and not known to many of the civil lawyers, but it is a civil relief. It is an injunctive relief. That relief is granted specifically under the Domestic Violence. Now, in the domestic violence relationship, it may be a relationship of a husband and wife, or it may be a relationship of live-in partners. Both are now well under our law. So there is shared residence or shared responsibility for that residence. And if that relationship or the marriage goes on the rocks, then the property and the right of possession of both the parties in that property would have to be protected. Generally, it is the right of the husband who protects himself, but the wife or the live-in relation female cannot protect it. So they go to the family court. And whether or not injunction should be granted. Now, the case that comes up is that if both parties are tenants, yes, grant the relief because both are tenants. They are joint tenants. So they will share the property half and half. There could be a workable order. You use the kitchen and one bedroom. You use the hall and one kitchen. You use it for this time or that time. And a kind of an injunction is given. Sometimes that doesn't work. So the wife says that there is domestic violence. He beats me up. He is an alcoholic. He comes home and he beats me up. Or he wants dowry. And I cannot give any more dowry. My parents cannot give. It is illegal and I'm not giving. So he beats me up. Let us say, for example. So restrain him from coming into the house. Now that injunction is for the entire of the house. You can't restrain him from coming into half the house. The question is, will you or will you not grant injunction? Now, some courts held that the husband is the owner of the property. How can you grant an injunction against the true owner? Wrong. It can be granted. And owner of the property is the jurisprudential legal owner of that property. He is not the owner of the person who lives in that property. He cannot do any illegal act. And I would give two examples to bring home this thing. One is if there is an unauthorized hut being constructed on the road, the municipality wants to demolish it. The person who has constructed the hut says, I am the owner of the hut. So you cannot demolish the hut. Grant me an injunction against demolition. Can the court grant injunction? No. He has done an illegal act. He has not come to court with clean hands. He is actually wanting an injunction against illegality. It cannot be granted. Take another example. The property is in a residential locality. One person puts up a gambling den. It is not allowed under the Bombay Police Act or under any of the police acts of other cities also. The police will come and lock up the premises. Can you get an injunction against the police restraining him from seizing and sealing the premises? No. The owner has done an illegality. Illegality is not allowed under the law, and therefore no injunction against that illegality can be granted. Now take the example of domestic violence. A husband beats up the wife in his matrimonial home. The wife says, protect me please, don't allow him to come into the house. So what if he is the owner? By being the owner, he cannot beat up his wife. That is an illegality. Violence is not permitted under law. It amounts to assault and battery, and it is a criminal offense also. It is harassment. It is criminal cruelty, whatever. This kind of injunction cannot be granted even against the true owner. If, of course, both parties are owners and they can separate and partition their properties, it can be given. Then, if the husband gives the wife half of that property but a separate property, then the wife must go. Then the wife cannot say, I want only this house. I had a case where the wife said, no, I want this very house at this very address. The husband says it's impossible to live with her. I am prepared to give her another house in a similar locality very close to my place, but please don't allow her to come into the house. Now, when that is given, then under Section 17 of the DV Act, there is some kind of a modicum of settlement. That is shared residence. And shared residence then becomes her private property. The house that the husband gives is owned by her afterwards. It's not only her matrimonial home where she has a right of residence only by pursuant to being a wife. It will be a house where that wife becomes the owner of the house. And that must be taken. If it is not taken, then an injunction against the husband can. So very interesting. Now, these are the principles set by the Supreme Court directions in various judgments. I'm not going to go into the judgments. This is not for that. No protected delays should be allowed. These are what I would call the restatement of the law. Everyone knows that this is the law. To cause delays, you cannot grant injunction. So, like for example, I told you in a suit under a loan, you pay 2 installments and then you delay. You get an injunction. No, that kind of injunction is not granted. To see irreparable mischief by the defendant, you cannot grant the injunction if that is irreparable mischief. And that mischief would be even delay and defeating the plaintiff's right, or not only defeating the plaintiff's. Then no ad interim order on a frivolous litigation. Like, for example, the example that I gave you of that Pan Bidi shop, distinctly in the compulsory open space where there can be nothing. It is a very frivolous litigation just to stop the municipality from doing its job upon the complaint of the society. No injunction can be granted. Injunction order after hearing the defendant, except where gross injury would be caused. Now, this is under Order 39 rule. So when there would be such gross injury, like I told you under the Anton Pillar injunctions or under Mareva injunctions, there would be a lot of loss. Somebody would take away the monies. Then only you grant without notice to the defendant. Otherwise, you grant notice to the defendant, hear the defendant, and then consider whether to grant or not to grant the injunction. Now, in arbitrations, as I told you, injunctions are emergency relief or interim relief under sections 9 and 17. And these cases have been taken from my book, Tangible Justice. Thank you, friends.
Good evening, ma'am. I'm just checking if Justice Manju has joined. No. As usual, it was explained in a subtle manner. But though you have taken up the issues, few questions for the audience, which they obtain, which we normally know as a professionals with experience. What are the 3 essential tests while granting the interim injunction?
That is what I told you in my slide. Prima facie case, balance of convenience, irreparable injury.
And then what you are told, just we are taking few questions so that people can understand in the end. What are the common mistakes a lawyer should avoid while drafting the injunction application?
One is that you should not draft a very long and verbose plaint which no one wants to read. In Bombay High Court, when Justice M.B. Shah was the Chief Justice, he saw that the pleadings in Bombay High Court were so verbose that something had to be done. And he said that you give a synopsis. We got the synopsis also of 25 pages. So the Chief Justice said that there must be a chronology of events and dates. That shows the whole thing. This chronology would show the documentary evidence. That documentary evidence would have to be seen. If you are relying upon any documentary evidence, make the main clauses bold in your plaint so that proper attention of the court is drawn to it. Even of the opponent to make a sensible reply. Then, please show what is a prima facie case, which is an arguable case. What would be the right of the plaintiff? How the plaintiff claims that right. And generally, we have these rights for property matters, and therefore there is documentary evidence. This is what the plaintiff should. So far as the defendant is concerned, the defendant must show whether the plaintiff has come to court with unclean hands first, whether it is a frivolous case and how it is a frivolous case, and show the law exactly for this. There is no need to show much more, but the defendant may rely upon some other clause of the document that the plaintiff has relied upon. And again, it should be that needlessly all sorts of defenses of misjoinder and non-joinder and all sorts of things should not be taken because it digresses from the main defense that the defendant would take up.
Now, the last question. It is, if you were to give 3 practical tips to a young advocate for arguing injunction matters, what would be that?
I would say, first draw a short plaint, make a short synopsis or an chronology. Always have a chronology, even if there are only 2 dates. That is what I was told by my senior. Even if there are just 2 dates that are important in the suit, write down those 2 dates. This writing down will show you various things, limitation aspect, delay aspect, all sorts of things, that way. So you do that. Then to show the prima facie case, go straight on to the prima facie case. Don't beat around the bush. Nobody likes to hear that in the court with the kind of the crores of matters that we have, thousands of matters before one single judge. And having done that, just sit down. So far as the defendant is concerned also, the lawyer must show the main defense. Nothing else. There was one matter where I was the lawyer and the plaintiff had gone to the Supreme Court. And we knew that there was no case, but you can never say it may be admitted or anything. I told the advocate on record in the Supreme Court, just a 1-page defense, mainly, just the points. You should not even turn your page. It should be 4 or 5 points on 1 page so that the judges can read at the time they are reading the SLP. The SLP was summarily dismissed. I don't know how. I'm not saying that it was because of those points, but that is how the courts will view. If you go on laboriously, you're going against your own client. Don't repeat.
Can an injunction can be claimed against a self-acquired property?
Against self-acquired property, yes, but by a person who has got an interest in the property. Now, suppose one man has got a property self-acquired. He has 2 sons. His one son takes care of him and lives with him and whatever. His other son has got a company flat. He has gone abroad, some such thing. Now that son wants to enter upon that property. It is self-acquired property of the father. He says that I am one of the heirs. No, he has no right at that time until the father dies. He can get no injunction. So against self-acquired property must be properly used. Self-acquired property of the plaintiff or self-acquired property of somebody else. And accordingly it will be seen. But injunctions can be granted for self-acquired properties as well as for joint properties as well as for Hindu undivided family, HUF properties. There is no bar.
Yeah. Last question. If there is any violation of the injunction, what remedy the party will have?
This is a civil breach and therefore a civil contempt. It goes under the Contempt of Courts Act. You have to make an application under Order 39, Rule 4 of the CPC. That is an application on contempt. He can be sent to civil prison for breach of an order of injunction. Okay. So generally, of course, that is not done. And the person in breach is, you can say, well advised to remedy that breach. And if that is done, it is accepted by the court and by the plaintiff, and the matter comes to an end. But if the defendant is very aggressive and would not listen, he can be sent to prison.
Yeah.
That is civil prison. We don't have anything like a civil prison actually. So in terms, he goes into a criminal prison. And this is for a period of not more than 3 months. But usually it is for a week or so. Which is bad.
Yes. Thank you, ma'am, for sharing your knowledge. And tomorrow, we are having a session to Mr. Sunil Arora, the Executive Director of BAL. This is BAL Asha Trust, Adoption, Practice and Procedures. So do join us tomorrow at 5:30 p.m. Thank you, everyone. Stay safe and stay blessed. Thank you once again, ma'am. We are indebted to you.
Thank you. Good night.